Hi everyone, I am Sam. Today we are going to talk about corporate law. Imagine for just a moment a medieval town square bursting with the hustle and bustle of merchants selling spices, textiles, and exotic goods. In the distance, you see ships docking at the port, carrying treasures from distant lands. Traders haggle for the best prices, and guilds, tight-knit groups formed to protect each member's craft, oversee the entire operation. These guilds are small, localized organizations, and each member bears responsibility for the group's debts, obligations, and even the occasional scandal. Fast forward to a modern-day financial district filled with shiny skyscrapers, towering bank headquarters, and big corporate offices. Each building, each large firm, and each brand might be backed by millions of dollars, thousands of employees, and a global network of suppliers. Yet strangely enough, the roots of these modern giants trace back to small associations of people banding together, much like those medieval guilds, just on a vastly different scale. In many ways, that transformation from the small medieval collective to the multinational corporation is the story of corporate law. To truly understand corporate law, we should start with one vital concept: the legal personhood of a corporation. A corporation, in simple terms, is an entity recognized by the law as having rights and responsibilities, much like a real person walking down the street. However, unlike that individual person, a corporation is a collective, typically formed by a group of investors or entrepreneurs who pool their money and resources. The intriguing part is that the corporation itself, the company, is separate from the people behind it. If we return to the medieval guilds for comparison, a guild did hold property collectively, but the members remained personally liable for any obligations the guild took on. If the guild owed money, it was each member's problem. But as centuries passed, people looked for ways to organize bigger, more ambitious ventures without exposing their personal assets to total ruin if something went wrong. The idea that an entity could exist independently of its founders, with its own rights, responsibilities, and liabilities, was revolutionary, paving the way for global commerce and, of course, modern corporate law. This notion of a separate legal personality laid the foundation for two critical legal developments. The first, limited liability, means that the individual investors or shareholders in a company are generally only responsible for the amount of money they invested. In other words, if the corporation fails, you lose the capital you contributed when you bought shares, but creditors cannot typically come after your house, your car, or your personal savings account, at least not in most standard situations. The second development, the transferability of shares, allows an owner in a corporation to sell off their piece of the company without necessarily dissolving the entire organization. So you can part ways with your stake and walk away, while the company continues as if nothing changed. These two pillars, limited liability and transferability of shares, granted enormous freedom to entrepreneurs and were a springboard for expanding business on a scale never seen before. We can step back into history to see where all of this began taking shape. Some scholars argue that examples of proto-corporations date back to ancient Rome, where associations, cooperatives, and municipal bodies carried certain rights. Over the centuries, medieval Europe had institutions like the aforementioned guilds, monastic orders, and even certain civic bodies that held collective property. Yet, it wasn't until the Age of Exploration, when European countries were sending ships around the globe in pursuit of spices, gold, and new trade routes, that the modern corporate idea began to crystallize. The English East India Company, chartered in 1600, and the Dutch East India Company, chartered in 1602, are often cited as the earliest large-scale multinational enterprises that functioned under what we would eventually recognize as corporate principles. These companies were granted charters by their respective governments, enabling them to trade with regions overseas, raise capital from private investors, and perhaps most importantly, operate with a structure that separated the company's liabilities from those of the individual investors. Imagine a group of English aristocrats, merchants, and adventurers pooling money to send ships to the other side of the world. If one vessel sank or was overtaken by pirates, the investors might lose their stake in that one voyage, but they wouldn't necessarily face personal bankruptcy. The East India Companies had enormous influence, So much, in fact, that in some places they acted almost like tiny governments, issuing coinage, negotiating treaties, and even waging wars. However, the model they established, raising money through share sales, distributing risks, and providing profits in the form of dividends, would prove unstoppable, eventually dominating large segments of global trade. The success and controversies of such early companies soon sparked debates about how governments should regulate them, what obligations corporations owed to society, and how the rights of individual shareholders should be protected. As the Industrial Revolution swept through Europe, and later the United States in the late 18th and 19th centuries, the corporate form became even more enticing. Factories, railroads, and mines required massive amounts of capital to build, operate, and expand. Partnerships, where each partner was liable for the entire enterprise, just weren't practical when you needed hundreds of thousands or even millions of dollars to start a project. Ordinary individuals might invest if they thought they would be protected from personal ruin. Legislatures began granting more charters and passing laws to standardize how companies could form, structure themselves, and operate. Thus, slowly but surely, corporate law morphed from being a rare privilege, granted to specific companies by royal decree or government charter, into a standardized framework that entrepreneurs could access more openly. In the United States, states took different approaches to incorporating businesses, sometimes leading to charter mongering, where corporations would seek the most permissive legal environment. A famous example is New Jersey, which, in the late 19th century, liberalized its incorporation laws to attract businesses. Before long, Delaware took that crown and remains to this day the most popular state for incorporation due to its relatively flexible corporate laws and specialized court system for handling business disputes. While this might sound a bit technical, the essence is simple. Corporations would choose to be governed by legal systems that gave them ample freedom to structure their affairs, handle shareholder relations, and manage their boards of directors. With the corporate form firmly entrenched in modern business, corporate law took on specific questions. How do you form a corporation? What rights do shareholders and directors have? How are conflicts between shareholders and the company resolved? How do we regulate giant corporations to protect the public? At its core, corporate law deals with the internal mechanisms of a company, its formation, structure, governance, and the duties owed by directors and officers to the corporation's shareholders, while also intersecting with broader public regulations covering issues like securities, antitrust, and consumer protection. Corporate law thus bridges private and public interests, trying to balance the freedom of enterprise with safeguards that maintain trust in the marketplace. One of the cornerstones of corporate governance is the idea of a board of directors. If we personify the corporation as a sort of ship, the board of directors is at the helm, steering the company's strategy and making major decisions, such as appointing the executive officers, think CEOs and CFOs, approving mergers or acquisitions, and declaring dividends. The directors are elected by the shareholders, who are, in turn, the owners of the company, at least in a financial sense. Although the directors have a certain amount of control, they owe what the law calls fiduciary duties to the corporation and its shareholders. Two primary fiduciary duties are often highlighted: the duty of care, making informed and prudent decisions, and the duty of loyalty, acting in the best interests of the corporation rather than for personal gain. Lawsuits often arise when shareholders believe directors have breached these duties, for instance by mismanaging company assets or giving unfair advantages to certain insiders. Delaware case law is filled with such legal tussles, setting precedents and refining the edges of how far directors can go before they cross a line. Essentially, the law tries to ensure that corporate leaders act responsibly, not recklessly, with the wealth that's been entrusted to them by the shareholders. However, within this framework, directors still have ample latitude to take calculated risks. Because courts generally won't punish them for honest mistakes of judgment, as long as they act in good faith and make decisions based on reasonable information. This principle is called the business judgment rule, and is an important protection for directors who otherwise might fear personal liability every time a corporate decision turns sour. On the shareholder side, rights include voting for the board of directors, receiving dividends if declared, and sometimes inspecting corporate books and records. In large, publicly traded corporations, shareholders are often numerous and scattered across the globe, from giant pension funds to day traders with just a handful of shares. These investors usually rely on the board's judgment rather than directly managing the company themselves. But even small shareholders can have a voice, especially when they band together, leading to shareholder activism, where groups of investors push for changes in the company's strategy, governance, or social policies. Think of it like a town meeting where members can speak up, only the town here is a corporation, and each share might represent a certain voting weight. As corporations grew and became integral players in society, they garnered both admiration and suspicion. On one hand, the corporate form has driven immense prosperity, funding technological breakthroughs and creating vast numbers of jobs. On the other hand, some worry that corporations can become too powerful, exerting undue influence on politics, the environment, and even everyday life. This tension leads us into another aspect of corporate law: regulation. Securities laws ensure that companies disclose important financial information so investors can make informed decisions. Antitrust laws limit monopolistic practices to foster competition. Environmental regulations require corporations to be accountable for the impact of their operations on our planet. We might think of corporate law as the skeleton of a company, the internal structure, while these broader regulations are the protective skin that ensures the company's actions don't harm the public interest. A compelling theme running through all of this is the constant balancing act. How do we encourage innovation and economic growth without giving companies free rein to do whatever they want? At different points in history, this balance has shifted. The laissez-faire attitudes of the late 19th century, which allowed vast industrial combines and trusts to flourish, eventually led to public outcry against monopolies. The 20th century witnessed periods of high regulation, particularly after major economic downturns or scandals. Today, we are in an era of globalization, digital transformation, and complex financial instruments, which challenges regulators and lawmakers to keep corporate law and related regulations up to speed. Now, let's turn to one of the most fascinating theoretical discussions in corporate law, often referred to as the debate between the shareholder primacy model and the stakeholder or social entity model. Traditionally, in many jurisdictions, the prevailing view is that a corporation exists primarily to maximize shareholder value. That means decisions made by the board of directors should ultimately serve the goal of increasing the company's stock price and dividends, at least within the bounds of legality. However, critics of this approach argue that focusing solely on shareholder profits ignores other groups who are crucial to the corporation's existence: employees, customers, suppliers, communities, and even the environment. Proponents of the stakeholder model suggest that corporate directors should consider the interests of all stakeholders, not just shareholders, because a corporation's impact extends far beyond its owners. Bank accounts. In practice, many jurisdictions and many companies straddle a middle ground. Some have benefit corporation statutes, which allow companies to write social or environmental goals into their charters, thus protecting directors who choose to make decisions that might prioritize sustainability over short-term profit. Others remain firmly committed to the idea that the best way to serve society is by focusing on profit, believing that successful businesses ultimately create jobs, drive innovation, and stimulate economic growth. This debate continues to shape corporate law reforms and influences how companies present themselves to the public, especially in an age when social responsibility is highly scrutinized. There's also an interesting debate about what exactly the corporate person is. The legal personality of a company grants it certain rights, such as owning property, entering contracts, and suing or being sued in its own name. Yet the extent of these rights, or the philosophical underpinnings of granting them, has stirred controversy. In the United States, high-profile court decisions have affirmed that corporations hold certain constitutional rights. For example, freedom of speech, raising questions about corporate influence on politics and elections. Such debates remind us that behind the seemingly dry framework of corporate law lies a world of ethical, political, and social considerations that shape our society in profound ways. For someone new to this topic, a helpful lens is to think of a corporation as a giant cooperative project. one that tries to bring together capital, labor, and resources under one roof to produce goods, services, and profits. Corporate law is the instruction manual governing how that cooperative project is put together. Who calls the shots, who gets to share in the gains, and what happens when problems arise. Because corporations can be vast, spanning multiple countries and employing thousands or even hundreds of thousands of people, the stakes are high. That's why the law has evolved with countless rules, precedents, and statutes aimed at guiding, restraining, or sometimes even punishing corporate behavior. Consider the scandals that make headlines every so often. Misstated financial statements, insider trading, or environmental disasters caused by corporate neglect. These events shine a light on where corporate law or regulation might fail or need reform. We see that with every major scandal, there is a renewed push to tighten rules around accountability or disclosure. The stock market crashes of 1929, 1987, 2008, and other financial crises often lead to legislative overhauls. Think of the creation of the U.S. Securities and Exchange Commission in the 1930s, or the Dodd-Frank Act after the 2008 crisis. In each case, the public outcry drives legislators to reevaluate how corporations are regulated and how corporate leaders should be held accountable for their decisions. Yet, despite these challenges, the corporate form remains an extraordinary vehicle for innovation and economic growth. Behind every groundbreaking product, be it a smartphone, a new medicine, or a rocket destined for Mars, there's often a corporation, or a web of corporations, channeling the expertise and capital of countless individuals. This collaborative power is precisely why corporate law continues to matter. It lays down the rules for how we as a society allow these potent organizational structures to form and operate. It sets the stage for how wealth is created and distributed, how responsibilities are assigned, and how conflicts are resolved when so many people and interests are involved in a single enterprise. No introduction to corporate law would be complete without mentioning mergers and acquisitions, often simply called M&A. This is the realm where entire corporations combine, or one swallows the other, or they spin off pieces of themselves like separating the branches of a tree. M&A can reshape entire industries overnight. When big tech companies merge, for instance, it can create concerns about reduced competition, prompting antitrust reviews. Corporate law provides the framework for how these transactions take place, how shareholders approve them, and what protections exist for minority shareholders who disagree with a merger. It's akin to a marriage between two massive organizations, except this marriage might affect thousands of employees, customers, and shareholders, and it must be documented and approved in detail. Another area that reveals the breadth of corporate law is corporate social responsibility, or CSR, which ties back to that stakeholder debate. CSR programs might involve philanthropic efforts, ethical supply chain management, or adoption of environmentally friendly practices. While these initiatives can be voluntary, they also align with growing consumer expectations that corporations do more than just chase profits. In some cases, laws and regulations mandate certain disclosures about a company's environmental and social impacts, pushing corporations to be more transparent and mindful. Whether such measures are effective or mere window dressing is another ongoing question in corporate law scholarship and public policy. In many legal systems, it's also possible to form variants of the traditional corporation, such as partnerships, limited liability companies, LLCs, and cooperatives, each with distinct legal rules. These alternative structures may be more suitable for small businesses, startups, or ventures that prioritize different goals than a traditional for-profit corporation. They all share certain similarities, like limited liability for members, but differ in governance and tax treatment. This patchwork of organizational forms underscores a fundamental reality. The corporate model might be the most famous, but it's certainly not the only game in town. If there's one takeaway from this broad historical and theoretical tour, it's that corporate law is not just about reading dense statutes or complicated case law. It's about understanding how groups of people collaborate under a legal framework to create value that can transform societies. The system isn't perfect. Corporations can make astonishing mistakes. They can exploit loopholes or overshadow smaller players. They can affect the environment and local communities in negative ways. But they also produce life-changing innovations, provide livelihoods for billions of people worldwide, and help us tackle huge challenges that no single individual or small group could manage alone. So, whether you're someone just dipping your toes into business for the first time, an aspiring entrepreneur hoping to build the next big thing, or simply a curious soul pondering how the world of commerce works, remember that corporate law is more than just rules and regulations. It's a story, a narrative that stretches back centuries, guided by ambition, shaped by innovation, and reined in by the need for order and fairness. From the spice-laden decks of old trading vessels to the digital realms of e-commerce, the essential lesson endures. When people join forces, they can accomplish wonders. And corporate law is the invisible hand steering that grand vessel across the seas of opportunity and responsibility. That's it for today, and I'll see you in the next episode.